All right. Well, good morning. Welcome to the Maryland Public Service Commission's February 14th administrative meeting, the Valentine's session. And the way we're situated up here just doesn't seem very Valentine's-like, but otherwise. I'll go ahead and let me start with a motion to adopt the February 7th administrative meeting minutes. Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted. Now I'd like to turn to our Assistant Executive Secretary, Mr. Kane, for today's agenda.
Good morning. We have three items on the agenda. On the consent agenda this morning, item number 1, Comcast Phone of Northern Maryland, Inc. Filed a request to detariff its regulated retail services. Item number 2, Granite Telecommunications, LLC. Filed a request to detariff its regulated retail services. And item number 3, National Institute of Standards and Technology, request for approval to construct a Type 2 generator in Gaithersburg, Maryland.
Great.
And those are the items for the consent agenda.
Very good. Are there any questions about the consent agenda? No. Very good. Is there a motion?
Yes, Mr. Chairman. I'd move for items number 1 and 2 that we grant the company's request to detariff their regulated retail services. And for item number 3, I move that we approve the construction of the requested generator that the Commission finds meets the requirements for exemption from the CPCN requirement as set forth in Section 7-207.1A of the Public Utilities Article.
Great. Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted.
There's been a suggestion that instead of calling item number 4 first, that we call item number 14. And item number 14 is the Eastern Utilities Commission. The Eastern Utilities Commission filed proposed amendments to PSC Maryland number 10 gas service tariff to include a provision for the installation of excess flow valves.
Good morning, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. Eastern Utilities Commission has filed revisions to its gas service tariff to include language regarding installation of an excess flow valve on the gas service line of a requesting and eligible customer. Excess flow valves are safety devices that are designed to restrict the flow of gas through the service line when the service line is severely damaged or cut completely through. The excess flow valve is installed as close as practicable to the service line's connection to the gas main. As of February 14th, 2017, the Federal Gas Pipeline Safety Regulations also require the installation of excess flow valves on new and renewed branch service lines serving single-family residences, multifamily residences, and small commercial entities consuming gas volumes not exceeding 1,000 standard cubic feet per hour. CFR Part 192 requires operators to notify customers of their right to request installation of an excess flow valve on service lines that are not newly installed or replaced. FSMA has left the question of who bears the cost of installing excess flow valves on service lines not being newly installed or replaced to the operator's rate-setting agency, which would be the Commission in this case. Since a qualifying customer with a new or repaired service line will receive an excess flow valve at no cost, staff recommends that a customer requesting an EFV on an existing line should be responsible for the incremental cost above the material costs of the valve. This would maintain the price signal because the incremental costs would still be significant. However, it will maintain equity among customers since the cost of materials associated with an EFV installation for a new or repaired service line are recovered through rates. Therefore, the material costs of the EFV associated with requested EFV installations should be recovered through rates, and this amount would be treated as a contribution in aid of construction. Staff recommends the Commission accept Easton's tariff for filing to be effective February 14th, 2018.
Great. Thank you. Let's see, I guess we can go to questions for staff. I was just going to ask, This appears to be very similar, if not the same, type of filing as the previous gas companies. Is that correct? Is there anything different about this one that?
It is virtually identical. The customer, ratepayers would be treated the same way relative if they ask for such a thing. The company had a provision in their tariff that dealt with this, but they have revised that language to be more consistent with what has come before you for the other companies.
All right, great, thank you. Any other questions? Commissioner Herman? Great, well, do we have a motion?
Yes, I move we accept the tariff revisions for filing with an effective date of February 16th, 2018.
Is there a second?
Second?
All in favor?
Aye.
Aye.
Opposed? Motion is adopted.
Item number 4, Windstream Holdings, Inc.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a filing by Windstream Holdings and Masscom, Inc. that request approval for Windstream to acquire indirect control of Masscom. In Maryland, the Commission has authorized Masscom to provide resold and facilities-based local exchange telecommunications service. The transaction here involves acquisition by Windstream of all the corporate stock of Masscom, with Masscom becoming an indirect subsidiary of Windstream. As a result of the acquisition, Windstream will become the indirect parent of Masscom, and approval of the acquisition is required under Section 6101C3 of the Public Utilities Article. The parties demonstrated that the acquisition will allow Masscom to become a more effective competitor in the telecommunications market. Therefore, we believe the acquisition is in the public interest. Therefore, staff recommends that the Commission approve Windstream's acquisition of indirect control of Masscom. I realize I misspoke. It's Windstream Services will be the actual direct purchaser. It's Windstream, the parent, that will be the indirect purchaser of the entity. Either event, it's a transfer of control, and that's where we think authorization is required, and we think the authorization is justified.
Great, thank you very much. Are there any questions for staff? Okay, is there a motion?
Yes, Mr. Chairman, I move that we approve Windstream Holdings, Inc.'s acquisition of indirect control of Masscom Incorporated.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted.
The next item on the agenda is OOEE 23 LLC.
Morning, Annette Garofalo again. OOEE 23 LLC seeks certification of its Whirlpool Corporation, Marion Wind Farm as a renewable energy facility. Staff has reviewed this application and believe the project qualifies as a Maryland renewable energy facility. Maryland Wind Farm consists of 3 generators powered by wind that have a rated capacity of 4.5 megawatts. The project is located in the PJM region and thus is eligible to receive Tier 1 RECs under Maryland's Renewable Energy Portfolio Statute. Staff recommends the Commission grant Marion Wind Farm's application and issue a certificate as specified in staff's comments. A certificate number, rather. The company should be directed to open an account with GATS within 30 days and file an on-site and behind-the-meter generation report with the Commission within 1 week of each recording of generation with GATS. Should the information on which the application is based change, Marion Wind Farm should be directed to file notice of such change within 30 days of the change taking place.
Okay, thank you. Are there questions for staff? Okay, is there a motion?
Yes, I move we approve the application and issue a renewable energy facility certification number, direct the company to establish a REC account with PJM GATS within 30 days of certification, and file an on-site and behind-the-meter generation report with the Commission within 1 week of each recording of generation data with the GATS, and finally direct the company to file notice with the Commission within 30 days of any change to the information in the application.
Is there a second?
Second?
All in favor?
Aye.
Opposed? Motion is adopted.
Item number 6, Monogram Clean Energy.
Good morning again, Mr. Chairman, Commissioners. This is related to not related to the item, but the same topic as the prior item, renewable certification as a renewable energy facility. This time the candidate is Monogram Clean Energy. They generate electricity from landfill methane and qualifying biomass under COMAR, a facility that seeking to obtain RECs for the renewable attributes associated with its generation must be certified by the Commission as a renewable energy facility. This facility is located in Virginia, which is in the PJM region, and under the Public Utilities article, a generation facility within the PJM region is eligible to be certified as a renewable energy facility. The project's capacity is 0.4 megawatts or 400 kilowatts. Staff recommends that the Commission certify Monogram's generating facility as a renewable energy facility with the conditions recommended by staff.
Great, thank you. Are there any questions? None? I guess we just need to channel, I guess, Commissioner O'Donnell, who would note that the facilities are in Virginia and Ohio, and of course would not be benefiting, I guess, economically Maryland at all. But other than that, is there a motion?
Yes, Mr. Chairman, I move that we approve the application and issue a renewable energy facility certification number, that we direct the company to establish a REC account with PJM GATS within 30 days of certification, and file an on-site and behind-the-meter generation report with the Commission within 1 week of each recording of generation data with GATS, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second? All in favor?
Aye.
Opposed? Motion is adopted.
Item number 7, Ecova Inc.
This, again, good morning again, Mr. Chairman, Commissioners, Kenneth Albert on behalf of staff. This item addresses a filing by Ecova Inc. that notifies the Commission that Ecova has changed its name to NG Insight Services Inc. The Commission has authorized Ecova to operate as both an excuse me, I have a little allergies there. Commission has authorized Ecova to operate as both an electricity and natural gas broker. Ecova has filed the name change with the Maryland Department of Assessments and Taxation, and they are in good standing to do business in Maryland. There are no unresolved complaints, and they're up to date on the Commission assessments. Therefore, staff recommends that the Commission note the name change.
Are there any questions for staff? Is there a motion?
Yes, I move we note the name change.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted.
Next items on the agenda, item 8 and 9, Insight Sourcing Group, LLC.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. These two items address requests by Insight for authorization to operate as an electricity and a natural gas broker. Their management has significant experience in the energy industry. They're active in several other states, and we've checked with those states, and their performance record there is satisfactory. We've reviewed their website and their training materials, and we find those satisfactory as well. Therefore, staff recommends the Commission authorize Insight to operate as an electricity and natural gas broker with the conditions recommended by staff.
Great. Are there any questions for staff? Did you do the second one also?
Yeah,
Okay,
I'm sorry.
okay,
yeah,
they
the
were
two-
together.
mention
Okay, I
the
just want to
two,
make sure
both
both
together.
were done. Okay.
Yeah, I'm sorry, two of them.
Great. Is there a motion?
Yes, Mr. Chairman. I move that for items number 8 and 9, that we grant the company a license to operate as a electricity and natural gas supplier in Maryland, limited to broker services, for the customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted.
Item number 10, AGN Energy Advisors, LLC.
Good morning, Commissioners. Peter Wolson on behalf of staff. This is another broker's license pursuant to Public Utilities Article 7507. AGN Energy Advisors LLC has filed for an application for a license to operate as a broker of electricity serving all customer classes in all Maryland service territories. AGN currently does business in 2 other states and has no complaint history. Staff has reviewed the application and determined that the company meets all requirements to grant authorization as an electricity broker as requested. The company has submitted the bond required by COMAR, and although it does not currently have training and marketing material specific for Maryland, staff has reviewed its website and finds it satisfactory. As a result, staff recommends the Commission grant AGN Energy Advisors a license to operate as an electricity broker as requested, direct the company to provide marketing and training materials specific to Maryland to Commission staff and the Office of People's Counsel 30 days prior to their use in Maryland, and direct the company to notify the Commission within 30 days of any changes to the information in the application.
Thank you. Are there any questions for staff? Okay, is there a motion?
Yes, I move we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for all customer classes and service territories, applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the Commission, staff, and the Office of People's Counsel 30 days prior to using the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted.
Item number 11, Energy Initiatives, Inc.
Good morning, Commissioners. Michael Dean on behalf of staff. Item 11 is an application filed by Energy Initiatives Incorporated to supply electricity in Maryland as a broker. Public Utilities Section 7-507 require the licensing of persons as electricity supplier by the Commission prior to engaging in that business. An applicant must prove technical and managerial competence as indicated in the prior item. The applicable law is the same. The application of Energy Initiatives requests approval to allow the company to provide electricity supplier services for commercial and industrial customers in the service territory of Baltimore Gas Electric, Delmarva Power, Potomac Edison, Potomac Electric Power Company, and the Choptank and Southern Maryland Electric Cooperatives. As the company does not yet have training and marketing materials specific to the Maryland market, staff requests the company to provide the material prior to commencing operations in Maryland. The company has met the Commission's financial integrity requirements by the posting of a $10,000 bond. The Commission has requested staff to investigate complete history of an applicant in other states. Pennsylvania had no records of any complaints against this company. New Jersey doesn't record complaints against brokers. And Delaware is still pending in its response to the Commission staff. The company has no complaints with the Better Business Bureau, and staff has reviewed the company's website and found it to be satisfactory. Staff concluded that Energy Initiatives meets the regulatory requirements for approval of its application. Staff recommends that the Commission grant the company a license to operate as an electricity supplier in Maryland, limited to broker services. Additionally, the company is directed to provide marketing and training materials specific to Maryland operations to the Commission staff 30 days prior to utilization of the materials in Maryland. Finally, staff recommends that the Commission direct the company to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license.
Are there any questions for staff?
Nope.
Okay. Is there a motion?
Yes, Mr. Chairman. I move that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services, for the customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Okay. Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted.
Thank you.
Item number 12, Secure Energy Solutions, LLC.
Peter Wilson again for staff. Pursuant to Public Utilities Article 7603, Secure Energy Solutions has filed an application for a license to operate as a broker and aggregator of natural gas, serving commercial and industrial customers only in all Maryland service territories. The company currently is licensed as an electricity supplier in Maryland and does business in 15 other states, brokering both electricity and gas. Staff has discovered no complaint history in those states. After an internal audit, the company has self-reported that it has inadvertently contracted to supply gas without the required license to one of its existing electricity customers since August 2015. The company assigns this error to employee negligence rather than a knowing and intentional violation, and has taken steps to correct the situation. Staff has determined that but for this violation, the company meets all requirements to grant authorization as a gas broker and aggregator as requested. Table 1, included in the confidential version of staff's comments, shows the revenues received by Secure as a result of its Maryland gas contracts for 2015 through 2017, as well as the assessments which would have been due to the Commission had Secure been licensed. In the past, the Commission has considered these amounts as well as the totality of the circumstances surrounding violations when assessing civil penalties, and those penalties have ranged from $750 to $2,500 for conducting business without a license. Given the circumstances in Secure's case here, staff recommends a civil penalty of $500 be imposed. For these reasons, staff recommends the Commission issue a civil penalty of $500 to Secure Energy Solutions, LLC, and, subject to the payment of that penalty, grant Secure Energy Solutions a license to operate as a gas broker and aggregator for commercial and industrial customers as requested. And in addition, to direct the company to notify the Commission within 30 days of any changes to the information in the application.
All right, thank you very much. If there aren't any questions, I'd like to make a...
I'm sorry.
Go ahead.
Yeah, I did have a question.
Okay.
That's my question, Mr. Chairman. Good morning, Mr. Wilson.
Good morning.
In the staff's comments on page 6, the staff noted that when discussing the range of penalties, it noted a range and then discussed the more egregious cases. Could you just give an example of what one of the more egregious cases would have been?
If I could ask Mr. Mosher.
Kevin Mosher on behalf of staff. This was actually, I think, some of the more recent decisions. In fact, we had the largest I recall was, I think, $20,000 or $22,000 fine, and in that case, it was because a broker had knowingly operated without a license over the course of a couple of years. We also previously, for a number of years, we always just fined companies $100 or whatever the back assessments they would have paid, but at some point, I think it was sort of determined that, well, the law's been in effect long enough that, saying you didn't know that there was an obligation to become a licensed broker in Maryland. But again, in those more recent cases, it's basically just, mostly someone's just inadvertently, like in this case, we were serving numerous, you were serving, say, a number of franchises in different states, and, one of your salespeople signed up this one. And I think some of the more recent ones have been like that. It's been, they haven't knowingly operated without a license, but in some cases it's been for a longer period of time, or they had a lot more sales.
Okay. Thank you.
Thank you. Do you have any questions?
I do. Have you had conversations with Secure?
Yes. Yes. The analyst who would prefer these, Alex, he has discussed. And they know. I'm almost certain he told them it was going to be a $500 fine we were recommending, and they seemed fine with that.
Okay, thank you.
Okay, I was, going to still propose that, given the circumstances in this case, it was self-reported. It seemed like it was not even just an honest mistake. They just were not aware of the situation, given I guess the salesperson who was dealing with this account, and that they have taken, I think very, important actions to try to correct the situation. That maybe we consider even reducing further the fee. The penalty, again, given that they do now want to, come to Maryland and do business, fully do business. So I was just going to throw out maybe in a reduction we consider just reducing to just past fees. Now I can't say them out loud here because it is in the confidential section, but that was going to be the proposal I'd like to offer my colleagues. I would propose that, we,
either keep the fee or reduce it potentially, but I do think that it's appropriate to assess a fee because ignorance of the law is not an excuse. And as Mr. Mosier noted, we've had these in the past, and there have been numerous, other instances where similar situations have occurred, and we've imposed a fine because it's been a long time now, and that companies need to get a license if they want to operate in the state of Maryland. So I would continue to support the imposition of a penalty.
Okay. Did you have did you want to propose a reduction, or did you want to leave it at $500?
I think if the company's aware that it's at $500, I'm not opposed to that. I'd like to hear what Commissioner Linton has to say if he has I'd like to hear what he has to say.
Yeah, me too.
Let's go there.
Me too.
Let's go with that.
I am, the commission spent a lot of time trying to find companies that were operating like this, some knowingly, most unknowingly. And in most instances, there were fines that were issued. Some of them were smaller than $500 because the company just weren't aware that they were operating in Maryland, similar to the circumstances that Mr. Mosier explained earlier. But a fine was almost always issued because, again, as Commissioner Herman already said, ignorance of the law is not a defense of it. But at the same time, we did want to encourage the companies to continue to do business in Maryland, and we recognize that they, in some cases, self-reported. So they didn't just file to get a license and just kind of operate as if it wasn't an issue. So I am okay with a fine. I think that that's in line with what we've done before. I've seen the amounts in different ranges. I'm comfortable with 500, but I would be comfortable with a smaller number, but I do think there should be a fine.
Okay. Then may I offer perhaps $250?
I'm comfortable with that.
Okay. All right. It's okay. I'll go ahead and then make the motion. I move that we direct the company to pay a civil penalty in the amount of $250 to the Commission, that we grant the company a license to operate as a natural gas supplier in Maryland, limited to broker and aggregator services for the customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application. Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted.
The last item on the agenda is NABA Energy Incorporated, item number 13.
Good morning again, Mr. Chairman. Kenneth Albert for staff. This item addresses a request by NABA for authorization to operate as an electricity broker. They have significant experience in the energy industry. They're active in other states, and their record in those other states has been satisfactory. Therefore, staff recommends authorizing NABA to operate as an electricity broker with the conditions recommended by staff.
All right, thank you. Are there any questions for staff? Is there a motion?
Yes, I move we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for all customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff and the Office of People's Counsel 30 days prior to using the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted. And with that, we are adjourned.